Good morning, everybody. My name is Yari Krivoy. I am Senior Research Fellow at the British Institute of International and Comparative Law, as well as Director of the Investment Treaty Forum. It's my pleasure to welcome you here at the first ever IETF webinar, which tackles a very urgent and interesting topic of how governments should respond to the coronavirus crisis without violating their international obligations, in particular obligations related to protection of foreign investors. So while the numbers are still climbing, we have already around 90 people in this room, and I think others are on their way to join this webinar. Make yourself comfortable, get yourself a cup of tea. I hope you will have a very interesting and stimulating event ahead of you. Over the last few days, there were several developments which are of potential impact of responses, of governmental responses to the coronavirus, as well as the potential for having investor-state disputes. Very few people doubt that there will be many investor-state disputes resulting from this crisis. And just a couple of days ago, several academics called for a moratorium on investor-state disputes because governments face an unprecedented pressure, and they have to take measures which are unpopular to save health and lives of their citizens. International organizations such as the United Nations Commission on Trade and Development are also working, trying to analyze the impact of the pandemic on foreign investments and on international investment dispute resolution. For example, UNCTAD a few days ago published a paper on policy responses which governments can adopt, and there are even recommendations in that paper. I'll share a link to this paper later on. So some governments are tightening foreign investment screening mechanisms. All governments are introducing new regulations to respond to the coronavirus, and many of those steps are not necessarily good for foreign investors. And probably there will be even more disputes in the future when the economic impact of the pandemic will become more obvious, and when there will be questions of who is entitled to getting, let's say, subsidies from the government. And there will be many other questions related to the legitimacy of governmental measures, whether the governments violated their obligations to treat investors fairly and equitably, what happens if the government expropriated a property of investor, there will be disputes probably related to compensation. And so there will be a number of also treaties reformed as a result of this pandemic. And I will not talk about the substance of this conversation because we have an excellent panel which will do that. Instead, let me just give a few updates about the activities of the Investment Treaty Forum. A few weeks ago, we launched an online course which was not planned to coincide with the coronavirus. It was a very long process. It took us probably a year to produce it, but now it's available, and it's quite popular with practitioners and government lawyers. If you are interested in this course, I'll send you a link. And if you want to have a group discount, please let me know later. I also managed to persuade our institute's management to offer free consultative membership to governments. So currently we only have UK governmental institutions which are consultative members, as well as some intergovernmental organizations. But if your government wants to benefit from being a member of the Investment Treaty Forum, in particular attending Investment Treaty Forum events for free or accessing resources which are available only for members, then please do get in touch with me. It's very simple. We'll just need to complete one form and then we'll add you to the database. On the 11th of September, we plan a big IETF conference on the right to regulate. The registration is already open on the BICA website. although it's not clear at the moment whether the event will take place in the normal format, an offline format, or it will be an online only conference, or maybe there will be a blended format with a few people gathered at the conference place, respecting social distancing rules, and others joining online. We will let you know in due course about that. When it comes to our today's event, there are a few things I wanted to draw your attention to. The first one, you will see a chat box and a Q&A window. So the chat box is essentially for you to share messages with others taking part in this event, or if you want to chat with someone directly, you can send a message, or you can share your messages with everyone in attendance. It is different from the Q&A box, which is essentially a place where we collect questions for the panelists. And I would like to ask you to hold on and keep your questions until the very end of all presentations, because maybe some speakers will address your question in the process. But at the very end, there will be an opportunity to ask questions, and you'll also be able to upvote those questions which you particularly like, so that the moderator, whom I am going to introduce in a moment, so that he picks up that question. We will also record the presentations, but we will not record the Q&A session. So the idea is that we want to encourage an honest exchange of ideas without being constrained by being recorded, so that others can see what you said. So the recording will stop after the last presentation here. Now let me introduce the moderator, Sir Frank Berman, who is an eminent arbitrator who also spent many years working for the UK government at the Foreign Office, most recently as legal advisor to Foreign and Commonwealth Office. Sir Frank also is a member of the ITF Advisory Board, and he used to be the chair of the Board of Trustees of BICL. So we're very happy to have him here among us, and he will moderate this discussion, including the Q&A session. Sir Frank, the floor is yours.
Thank you very much, Jarek, and welcome to you all in this format, which is unusual. And it's an unusual format that we're all getting used to as part of our life under these extraordinary conditions. I may say, as an arbitrator, that this kind of format is one which I have for years been urging for use in arbitral hearings, at least hearings of certain kinds. And I derive a certain malicious pleasure from the fact that circumstances are forcing this upon us for our consideration. However, let me add to Jarek's welcome. I add to Jarek's welcome firstly by paying tribute to Jarek himself for his energy and his initiative to make quite certain that whatever else may have been put into lockdown or even closed completely, it is certainly not the British Institute of International and Comparative Law or the Investment Treaty Forum. I would much rather, of course, be seeing all of you in one room in the usual way. I'm very impressed by the attendance that this session has gathered, which I notice is made up of three sectors. There are people representing the governmental side. There are the majority of people are practitioners, and there is also a nice admixture of academics. So we have an excellent panel who represent all three of those sectors. We're going to begin by giving the floor to Valentina Vardi, who has a professorship of international economic law at the University of Lancaster, and particular experience in her own academic work in the health sector. Next, we will hear from a governmental perspective. Miriama, who has been for some years before she went to the Slovakian permanent representation in Brussels to the European Union, responsible for handling investment treaty matters for the government of Slovakia. And as she reminded me a couple of days ago, she has rather more than average experience in dealing with disputes relating to the health sector. And then our third panelist is Jeffrey Sullivan of Gibson, Dunn and Crutcher, a partner in their London office with great experience in handling of investment treaty cases from the point of view of the investor. Now, I'm not going to give you anything more in the way of background myself about what might happen. The COVID coronavirus pandemic is an overwhelming emergency which has struck us all in every aspect of life. And I think as each day goes by, we realize how many of the large and also the tiny corners of life has been severely affected. So it's hardly surprising that we in the Investment Treaty Forum should also want to look at least in an advanced form, at the potential effects. I'm not going to give you any further overview from my own part. My professional life now consists of being an international judge and arbitrator. And curiously enough, although this is sometimes a shock and surprise to my academic colleagues, I think that the role of an international arbitrator is to consider the case which is presented before the tribunal by the parties and decide upon that particular case. I don't think it's a function of an arbitrator to forecast in advance the kinds of disputes that might arise, or less still, how those disputes should be dealt with. But we look forward to an extremely interesting perspective on all of that on the part of our three panelists. Questions afterwards, as Jarek said, that's designed to be a free and confidential exchange between all of us. I do urge you to follow Jarek's advice. Wait as if we were in a meeting room and put your questions down once we've come to the end of the panel presentations. I will exercise the chairman's prerogative to select questions to put to the panel. Only one particular point, please. I will disallow any question which is put in the form of, this is a question for X, Y, and Z. We sit here as a panel, although we're separated in space, we're together as a group. So this is designed to be a panel discussion. And that's it. So I'll now pass directly on to Valentina Vardi to start off the panel presentations. Valentina.
Good morning, everybody. Thank you for inviting me. It's a great honor to present part of my current research to you today. So I was asked to briefly introduce the interplay between public health and investors' rights protection under international investment law. So the big key question of my presentation will be, can international investment law successfully address the legal issues that can arise and are related to the COVID-19 pandemic? As we know, the virus has killed more than 240,000 people, and the UN Secretary General Antonio Guterres warned that the world is facing the most challenging crisis since World War II. States have adopted a range of public health policies, and such public health measures have brought economic life to almost a standstill, and inevitably they have affected many foreign investors. So in my presentation, I will briefly highlight the most relevant legal issues. I am not providing legal advice. I am an academic, and I'm briefly trying to highlight the most crucial legal issues. Other professionals are dealing with with a huge crisis. So I think that as lawyers, as professors, it's our duty to provide a reflection on how states are reacting to this crisis to protect public health. So my presentation is divided in 3 parts. First, I will examine what kind of claims can be raised, and I will examine the inherent flexibility within investment treaty provisions. The second part will briefly touch upon what kind of defenses can be raised, and this part will be very, very short because other colleagues will address this specific point later. And finally, last but not least, I will briefly touch upon the possibility of the adoption by the international community of a waiver according to the principle of fundamental change of circumstances, or the clause rebus sic stantibus. But first of all, what kind of claims could be raised and how investment treaty provisions can enable some inherent flexibility to adjudicators. In my presentation, due to time limits, I will focus on 3 main claims that could be raised: fair and equitable treatment, breach of fair and equitable treatment, non-discrimination, and expropriation. And I will show how treaty provisions do enable arbitrators some flexibility in evaluating whether there is a breach in the first place. So with regard to fair and equitable treatment, this standard is almost in every investment treaty, and there is no commonly accepted definition. So usually this standard is deemed to include access to justice, due process, good faith, and the respect of legitimate expectations of investors. It generally requires the adoption of transparent and consistent regulatory framework. Investors could contend that adopted measures are in breach of due process, are unreasonable or disproportionate, or are altering the existing legal framework, thus being in breach of fair and equitable treatment. Nonetheless, as investment lawyers know, this standard does not require states to freeze regulation and their legal framework. Since the beginning of the crisis, all countries around the globe have unavoidably adjusted their policies because this pandemic was unknown before December 2019. So it would be unreasonable to pretend that states kept mild responses when the crisis intensified. Moreover, the crisis also shows that the proportionality test that has been adopted by a minority of arbitral tribunal can be inappropriate to assess public health measures. Countries like New Zealand opted for going hard and going early. They imposed quarantine on anyone entering the country and implemented a strict lockdown weeks later, when fewer than 150 people had been infected and none had died. This action has not only saved thousands of lives, but it has also enabled the country to reopen earlier than other states. Counterintuitively, a more gradual action might have caused a disproportionate number of deaths. So not only developing countries, but also industrialized countries may legitimately adopt precautionary approaches to prevent the spread of the pandemic. Vice versa, a question might arise: could a state failure to take early measures to contain the spread of the virus violate the fair and equitable treatment standard, if such failure then necessitated more stringent measures afterwards? Past claims that have attempted to enforce environmental law through the use of investor-state arbitrations have failed. So there are a couple of cases in which the investor tried to enforce environmental law using investor-state arbitration, but this, of course, would not be the appropriate place to adjudicate those claims. So, in conclusion, provided that the adopted measures were rational and reasonable, arbitral tribunals should not second-guess measures adopted during the pandemic. The existence of international standards can provide a useful benchmark. However, states can adopt more ambitious measures adapted to specific national risks and capacities. International health regulations are a broad framework for action. But states, of course, can go beyond these benchmarks. And according to recent arbitrations, the fair and equitable treatment must be calibrated by the circumstances of the host state. In Philip Morris versus Uruguay, the arbitral tribunal was satisfied that the fair and equitable treatment did not preclude governments from enacting novel rules, even if these were in advance of international practice. With regard to non-discrimination, very briefly, let us recall that legitimate regulatory distinctions may be upheld by arbitral tribunals if they pursue legitimate public interests, are taken in good faith, and are reasonably tailored to achieve such interests. A very interesting case in that regard is Parkerings versus Lithuania. Now, with regard to the third type of claim, expropriation, as we know, expropriation can be direct or indirect. In order to be lawful, there are 4 general requirements that, of course, the measure has to be taken in the public interest, must be non-discriminatory, it must provide compensation, and must follow due process. With regard to indirect expropriation, of critical importance is the distinction between regulatory measures that do not constitute expropriation in the first place and indirect expropriation. Now, in order to identify the regulatory measures that are not expropriatory in nature, there are different doctrines. The sole effects doctrine focuses on the economic impact of a given regulatory measure on investors. The police powers doctrine, however, which is an ancient doctrine which belongs to customary international law, considers that general regulation adopted in good faith in a non-discriminatory manner to protect public health cannot be compensated. And this argument nicely drives us to the second part of my presentation, potential state responses. So in the first part of my presentation, I show that, in fact, the vague investment treaty provisions do include some flexibility, inherent flexibility. However, if a state somehow was in breach of investment treaty provisions, of course, there are some defenses that can be successfully invoked by states. With regard to the protection of public health, this is not only a fundamental interest of states, but also a fundamental duty, derived not only from human rights law, but also from the fundamental compact between the state and its citizens. The population of a state constitutes not only a component part of the state, together with the territory and government, but also its very reason of being. Therefore, the protection of its population is a paramount interest of states, and it's also a traditional component of the police powers of a state. Now, the term police may be misleading, but in fact, police derives from the Greek word politeia, which means community. So those powers indicate the state duty to protect public health. And we have a line of very important cases showing that measures adopted in the exercise of police powers are non-compensable. In the Bishop case, the umpire stated that certainly during an epidemic of an infectious disease, there can be no liability for the reasonable exercise of police powers. More recently, in Philip Morris versus Uruguay, the arbitral tribunal stated that protecting public health has long since recognized as an essential manifestation of the state's police power, and this forms part of customary international law. With regard to exceptions, there can be treaty exceptions, and the more recent investment treaties do include a range of safety veils that enable the parties to deviate from their respective obligations. So I know that other colleagues will focus on this. Very briefly, some investment treaties include general exception clauses which mention public health. There are also security clauses. And of course, the concept of national security is an evolving one and can include the fight against a deadly pandemic. Some security clauses are expressly self-judging. Other security clauses are not. Generally, arbitral tribunals have adopted a very conscientious scrutiny of measures adopted by states under this security exception clause. However, this scrutiny may be a good faith review, also accordingly to what other international courts and tribunals have done recently. I'm referring to other international courts and tribunals. Finally, of course, there are also customary international law defense, such as force majeure, distress, and necessity. I leave this to the next speakers, because I know that this will be dealt more in detail by others. But of course, we can talk about this during the discussion. I concluded this presentation with my third point and some provisional conclusions. My third part briefly concerns the idea that we are facing exceptional circumstances, and the principle of change of circumstances is one of the fundamental principles of international law, together with pacta sunt servanda. If a fundamental change of circumstances has occurred after the signing of the treaty, which the parties could not expect at the time of the negotiation, the contracting states may invoke the principle of change of circumstances in order to protect their legitimate interest. So some scholars have advocated the adoption of a waiver by the international community so that no claims could arise out of the extreme circumstances that we are facing now. This is not unprecedented. This has been done within the World Trade Organization relating to specific issues like conflict diamonds and other important issues dealing with human rights and other important issues. So this would not be unprecedented. So if no international consensus could be reached on this moratorium that has been proposed by scholars, of course, the states could also invoke this fundamental change of circumstances that is part of customary international law and is also restated in the Vienna Convention on the Law of Treaties. Now, my conclusions, I have 3 points. First, investment treaty provisions are vague but their vagueness can also enhance their legitimacy in the sense that arbitral tribunals checking whether a specific clause, a specific provision has been breached, may use the vagueness of the treaty provision to ascertain whether a breach has taken place in the first place. If a breach nonetheless has taken place, of course, states do have a range of defenses. Some of these defenses are explicitly mentioned in the investment treaties in the form of exception provisions, general exceptions, security exceptions. But even if the treaty didn't include such specific and explicit exception, there are norms, customary norms, relating to circumstances precluding wrongfulness. And in interpreting these flexibilities, which do belong to international investment law, these flexibilities have not been created now. These flexibilities have existed for centuries. Of course, arbitral tribunals do need to make the most of the flexibilities that are included in these treaties. Last but not least, I refer to the fundamental change of circumstances, the rebus sic stantibus principle. Again, this belongs to customary international law and has been part of international law since the 17th century. So ideally, the international community could consider adopting a waiver, given that almost all states have been or will be soon affected by the pandemic. And if not, of course, a state will have the possibility to invoke this provision in possible disputes. I thank you for your attention, and I look forward to possible comments, remarks, questions. Thank you.
Thank you, Valentina. Our next panelist is Mirjana Kiselová of Slovakia, who's talking to us from Brussels this morning. Mirjana.
Good morning, everybody. Many thanks to Eric for organizing this webinar. It's very useful, I think, to meet even in this special forum. I have prepared PowerPoint presentation so that it's easier for you to follow me. So I hope everybody can clearly see it now. So I would like to focus my presentation in three parts. First one is the Slovak response to COVID-19. Second part will be the Slovak experience with arbitration in the health sector, which can occur, as I will explain later. And the final part will be the interplay between COVID-19 and international investment agreements. Before starting my presentation, I would like to underline that I'm speaking on my personal capacity, and my statement should not be attributable to the Slovak Republic, and this is not considered as legal advice. So regarding the overview of the Slovak measures which were adopted to fight against COVID-19, I'm providing only a short overview. This is because all the measures could be found at a website which was created for this purpose, corona.gov.sk. Extraordinary state was declared in the Slovak Republic since 12th March 2020. Many measures were adopted. Basically, the most relevant, which I would like to underline, were the temporary reintroduction of the border controls. Some know it as closed borders, but of course it's not completely closed. It's still possible to enter the state, but under certain conditions. Closed shops and operation of certain services. Here again, of course, there were exceptions, for example, to groceries, to pharmacies, and certain other shops. The gatherings were prohibited, attendance of schools, sport events, etc. And one of the measures that were also introduced were tracking the cell phones in order to track the spread of the virus. Currently, the Slovak Republic is already in the exit strategy. The first phase of exit strategy started on 22nd April with the opening of the small shops and service providers. Since our spread of virus in the terms of COVID victims is relatively low, we have decided to join the second and the third phase together on 6th May. They started, which is yesterday. So this second and third phase of exit strategy means that more shops were opened, also, for example, hotels, taxi services, beauty parlors, etc. And the last fourth phase is planned for June 2020. So this is the overview of the Slovak measures. Of course, I haven't mentioned all of them. This is just to give the basic idea. Regarding the statistics, how the Slovak population was hit by the virus, as of yesterday, there were more than 100,000 tests. Only 25 people died, and approximately 1,400 have the virus as such. So now I would like to share with you the experience of the Slovak Republic with the investment arbitration in the health sector. As it was already very, very eloquently explained by the previous speaker, the states have a wide right to regulate. They have both duty and right to adopt measures to protect the health of the population. Despite this, it doesn't mean that health as such cannot be, health protection cannot be the object of international investment arbitration. The Slovak experience is related to the health insurance, in particular the so-called benefit from public health insurance. I will very briefly explain the origins of this. Originally, in the Slovak Republic, there was only one state health insurance provider. Later on, other private entities entered this sector, and in 2004 they were allowed to produce profit from public health insurance. Due to negative reactions from this creation of the profit from public health insurance, the Slovak Republic introduced the so-called benefit, which was a later reason why several arbitrations started against the Slovak Republic. These three arbitrations are Achmea 1. This arbitration ended in 2012 by an award, which was subsequently subject to set-aside proceedings. It ended up before the Court of Justice, which in 2018 decided on inapplicability of arbitration clauses within the member states, and the award was later terminated by the German Supreme Court. The claimed violations were fair and equitable treatment, indirect expropriation, and transfers. Basically, these three alleged claims appeared in other arbitrations as well. The second arbitration was Hice versus Slovak Republic. Here the claimed damage was almost 800 million euros. It was won in the jurisdictional phase in 2011. The proceedings before the Slovak court was held in parallel. It is still pending. Last year we won the first instance proceedings. The third arbitration, which was triggered by the ban on the ban of profit of the health insurance, was the Uram Bank against the Slovak Republic. This arbitration claimed 139 million euro as compensation. And we also won this arbitration in the jurisdictional phase in 2014. So these were the 3 arbitrations which were related directly to the so-called ban of profit. After these arbitrations, the Slovak Republic still tried to modify the public health insurance sector by a plan to create a unitary health insurance company, which basically triggered the fourth dispute, fourth investment arbitration started by Achmea as well. We also won this arbitration in year 2014 in jurisdictional phase. And here I would like to quote from the tribunal. This arbitration is specific because the claimant basically started the dispute before the act was even adopted. It was during the legislative phase. During the phase of creation of the act, and this was the main reason why the claim was rejected, and the tribunal explicitly stated that it is not empowered to intervene in the democratic process of a sovereign state and cannot do so absent very specific language to that effect. The design and implementation of its public healthcare policy is for the state alone to assess, and the state must balance the different and sometimes competing interests, such as its duty to ensure appropriate healthcare to its population and its duty to honor its international investment protection commitments. End of quote. So this is the last arbitration which we had in relation to the healthcare and public health insurance. Which brings me to the last part of my presentation, which is the prevention of claims. Again, I share the opinion of the previous speaker that this is extraordinary situation. It's a state of emergency. States are facing great challenge and they are trying to protect the health of the population. Nevertheless, it cannot be excluded that certain investors will try to commence investment arbitration. So here I'm providing a few opinions, ideas how to try to mitigate the risk of claims. So first of all, it's clear communication and transparency. I think this is not only for foreign investors, but it is very clear for the other citizens as such. They should be properly informed what kind of measures are being adopted, what is their purpose, and when do they start to apply, and possibly also when do they stop to apply, so that they are duly informed. Second proposal is the proportionality of the adopted measures. It means, for example, in case the state wishes to track the spread of the disease, it's enough to limit itself to the tracking the phones as such. It's not necessary to track the telephone conversations or the exchange of the messages. The third point is focused measures. Here I'm basically trying to explain that if the measure is adopted in the fight against COVID, and especially if it's adopted in faster legislative proceedings than usually, it should also remain focused well on the fight against the spread of the disease. The fourth point is justified differentiation. This is related to the fact that, especially as you can see in exit strategy, different retails, different entrepreneurs can start reopen their operation in different time. This is due to the fact that, for example, if the operation is a small one, of course, it can be introduced in the earlier phase of the exit strategy as to in comparison to, for example, shopping malls where the concentration of people is much higher. So most likely they will be open in a later phase. The fifth point is justified protection of critical assets. Here I'm basically making a short reference to the fact that EU has already adopted the regulation on the screening of foreign direct investment. Later on this year, in relation to COVID, the European Commission issued guidelines in relation to the foreign investment and COVID, and several states already adopted screening of foreign direct investments, and some states are planning to do so in this relation. So here, of course, if it is adopted for the sake of protecting security and public order, and the focus is also on health relation. The last point is very general. It's observing of law, which means both national and international obligations in this relation. The second part of the prevention of claims, here I would like to focus on both economic measures that are state adopting to mitigate the loss of the entrepreneurs, and the final part will be the potential change of model BIT, which the states may consider. So states are adopting a lot of measures to compensate the economic impact on the investors. I have just mentioned several of them, which have already been introduced in the Slovak Republic or are contemplated. It's the Kurzarbeit. It's the concept of compensating part of the wage by the state if the company had to temporarily close its operation. Second is the direct financial contribution to the employers. Also deferral of social insurance premiums, of payment of taxes, deferral of payment of loans or mortgages. Then also bank guarantees, which means the guarantees by the state to the banks in order to provide loans, especially to the small and medium enterprises. So these all are measures which are adopted in relation to COVID, but in order to mitigate the loss, and this shall be duly taken into consideration. Last but not least, as it was already started by the previous speaker, the states may consider for the future to modify their model BITs for the future negotiation of the bilateral investment treaties. The latest Slovak model BIT is from 2019. It's a very balanced treaty protecting right to regulate of the state, and there are several provisions which directly focus on health protection, which is the right to regulate itself, then the provision on indirect expropriation, when if the measure is proportionate and non-discriminatory, it doesn't contribute the expropriation, and also basically the provision of no race to the bottom by decreasing the health standards. So basically this is everything, and I'm happy further to reply any questions. Thank you.
Thank you very much, Miriam. And then our last speaker on the panel is Jeffrey Sullivan of Gibson, Dunn & Crutcher. Jeffrey is unique amongst us on this panel in that his wide experience in the field has involved both sides, both representing claimants in advancing their claims and representing states in defending against them. Jeff, the floor is yours.
Thank you, Sir Frank, and thank you also to Jarek and Bickel for asking me to speak today. The specific topic that Jarek asked me to speak about is the controversial issues that we may see arise as cases are brought in response to governmental measures taken in response to the pandemic. There probably will be quite a few controversial issues. Investor-state dispute resolution is always full of controversy. And I'll focus today on four issues in particular. Let me start first by going into a bit more detail about where we are today, and both Jarek and Sir Frank have already covered some of this ground, so I'll do this quickly. But I think it's safe to say that the scale and the form of the governmental response to the pandemic is unprecedented, at least in peacetime. We have entire countries locked down, travel bans put in place, mass gatherings have been suspended, quarantines have been imposed. These are the social distancing guidelines. On the economic front, we have businesses shut by government order, export restrictions imposed, even demands that certain manufacturers stop their core production and switch to the production of ventilators in certain countries as well. In tandem with those actions, we also have economic stimulus packages that have been put in place to shore up the economy, given the devastation that has come down on the economy as a result of the pandemic. And those are on an extraordinary scale. The US initial package was worth $2 trillion US. Here in the UK, 350 billion pounds. Across the EU, I think it's currently at least 500 billion euros. And I think this is probably the beginning, more economic stimuli to come. This sort of governmental action, I think, was unimaginable at the start of the year. In fact, I remember very clearly having a discussion in January when Wuhan was shut down with a colleague who said, can you imagine a city of 11 million people? That's a city the size of London being completely shut down. And of course, 2 months later, that's exactly what happened in London. Now, the aims for these governmental actions are relatively simple. From a health perspective, as both Valentina and Mariama had mentioned, the purpose is to bring down, keep down the transmission rate of the virus to a level at which the health systems can cope. And then from an economic perspective, the stimulus packages are designed to keep companies in business and to keep people in their jobs. But these steps are taken at speed. These are significant governmental decisions. And I think it is inevitable, as others have foreshadowed, that you will see disputes arising out of this. And just last week, here in the UK, there was a legal challenge threatened against the government as a result of the lockdown. It's only a letter before action at this stage. It hasn't actually been lodged, but the letter suggests that the government's lockdown measures were, amongst other things, disproportionate, that they do not, in fact, serve the stated goal of public health. So you're already seeing domestic legal challenges being brought here in the UK. There are challenges being brought in other countries as well. So with having seen domestic challenges, I think it is inevitable that we will see investment treaty claims. My personal view, at least at this stage, is we may not see an explosion in cases that some people have predicted, but I do think there will be cases. Now, the governmental actions I've just described, I think, fall into three broad categories, and it's helpful to think of those three categories when we start to think about the controversial issues that may come out of potential claims. The first category, as I mentioned, are decisions which affect business as usual. These are the compulsory work from home orders, the restrictions on movement, the closure of businesses, restrictions on exports, things like that. So decisions affecting business as usual, I think, is the first category. The second category is the economic stimulation packages. I've mentioned those already. And then the third category are the measures taken to protect strategic assets or strategic sectors. And Mariama mentioned some of these, but we have Canada, for example, vowing to take actions necessary to stop predatory foreign investment. France, Japan, Spain, many countries have tightened their foreign investment screening rules. There's been nationalizations of certain industries, hospitals in Spain, for example, Alitalia in Italy. So that's the third category. So what will be the controversial issues? I said I'm going to talk about four. The first one, Valentina helpfully mentioned already, which is the issue of proportionality. And proportionality, of course, is one of the tests that's often employed by arbitral tribunals to determine if a measure is arbitrary or unreasonable, such that it violates the investment treaty. And as I mentioned, this is the basis for the domestic legal challenge that may be brought here in the UK. So the question around proportionality and the controversy around proportionality will be, I don't think there's going to be any dispute that steps needed to be taken by the government, but did the government go too far? And how is this judged? The information the government had at the time of the decision is really the key question. You can't look at this question with hindsight. We will know a lot more about the virus and how fast it moves and who it affects a year from now, but these decisions that were taken at speed, and governments had limited information. They were still learning about the virus. And so that's something that needs to be, I think, borne in mind by future arbitral tribunals. And of course, you may see arguments made that different countries took different approaches. Some were more successful than others, and that all governments should have taken uniform approaches. Valentina mentioned New Zealand, who very early took a very strict approach. That's one end of the spectrum. At the other end of the spectrum, you have Sweden, who's made very few or put in place very few restrictions. Of course, in most of Europe, Italy, Spain in particular, we had the entire economy essentially shut down and people confined to private residence. Then you have the countries who've adopted what could be argued to be the third way. Those countries that have emphasized testing, South Korea, Germany, for example, maximized early testing. And at least it seems at this stage that was a successful strategy. So should a government be held responsible for the decisions it took at the time? Did they overreach? Did it go too far in its response? And this is the question of proportionality that I think will be highly controversial in cases that were brought in response to the pandemic. The second issue is the right to regulate, also mentioned by both of my co-panelists. And I think future cases that may come from the pandemic will bring into sharp focus this question as to when governmental action crosses that fine line between a state's right to regulate and a violation of a treaty. Probably one of the hardest things, one of the hardest issues in investment treaty cases anyway, but this pandemic will bring that issue into sharp focus, I think. As Sir Frank already mentioned, arbitrators decide cases based on the facts before them. And so it will be a careful examination of those facts, and it will be the difficult task to decide if that line has been crossed by arbitral tribunals. There is obviously a lot of law on the right to regulate. It is generally viewed as a principle of customary international law. I also have come across the Bischoff decision that Valentina quoted, which I think is certainly relevant. It's the German Venezuelan Claims Commission decision of 1903, dealing with a question of expropriation in response to a smallpox epidemic. And the quote, which Valentina mentioned, is that certainly during an epidemic of an infectious disease, there can be no liability for the reasonable exercise of police powers. So that concept already exists. The economic stimulation packages may also give rise to claims, and we have some experience of this from the 2008 global financial crisis. But again, you see clear lines being drawn in some of these cases. I'll refer you to the Marfin versus Cyprus case, which found that the Cypriot government's acquisition of a stake in a bank, which resulted in the dilution of the shareholders' interest, did not equate to illegal expropriation. And quoting from that case, the tribunal said, non-discriminatory proportional measures taken in good faith in the pursuit of a legitimate public policy objective, the protection of the health of Cyprus's financial system during a time of profound economic crisis, is how they described the action. And of course, they found no violation of the treaty. But when that line is crossed, as I said, is the difficult question, and that's where the controversy will arise. One of the reasons I don't think there will be an explosion in cases is I think a well-advised client will understand that many Can you hear me, Sir Frank?
I hear you now. Thank you, Jeff. You were saying something about you didn't think there was going to be an explosion of cases because a well-advised client, and then I was poised to hear what a well-advised client would do.
Well, I think a well-advised client will understand that the police powers doctrine is part of customary international law, and will understand that it's not appropriate to look at these cases with hindsight. So I don't think there will be an explosion of cases, but there will be cases. And the right to regulate does not give a state carte blanche. We have seen other states take actions which I think on an objective view are not directly responsive to the health emergency they're facing or potentially disproportionate. We have certain states where a prime minister has been authorized to rule by decree. We have states which have granted broad powers to punish people for spreading false information, including imprisonment for criticizing the government's response. And again, these are the types of outliers that may give rise to legitimate cases. I wanted to touch very briefly on the CCSI proposal that Jarek mentioned about the possibility for a moratorium on ISD cases. And that proposal presupposes that there will be a substantial number of cases. The language they used is quote, a massive number of unjustified claims. And I, as I've already said, my personal views, I don't think that's a safe starting premise. But there shouldn't be a ban on cases. The system is designed to protect investors from governmental abuses, and those abuses can occur even in a time of crisis. And as I've mentioned, governments do sometimes use the cover of a crisis to take actions that otherwise they would not be able to take. The third controversial issue is what I'll title different treaties, different results, something that has plagued the ISDS system for quite some time. And I think it will give rise to controversy here as well. Modern investment treaties, as Miriam mentioned, expressly carve out a right to regulate to achieve legitimate public health objectives. And we see that in the CETA, for example. The China-Australia FTA expressly precludes claims on the basis of non-discriminatory measures put in place to protect public health. But in older treaties, there's no express provisions that provide for this right. And so one question and one potential source of controversy is if tribunals decide these cases in different ways based on the specific language in the treaty. And of course, there is an argument that if you take a very strict Vienna Convention approach to the text of the treaty, a tribunal may view that the state's right to regulate is broader under some treaties than it is under others. And that again could lead to controversy. The fourth and final issue I'll mention is the scope of the necessity defense. I think we may see a resurgence of the controversy around the scope of that defense. We saw a first set of cases which gave rise to great controversy about the scope of the defense arising out of the Argentinian financial crisis 20 years ago. To sustain necessity of defense, the state must establish a grave and imminent peril that threatens an essential interest. It must establish that it did not act seriously, its acts did not seriously impair another essential interest. And it must prove that the action taken was the quote, only way, that it didn't go too far in safeguarding the essential interest. These are tricky issues. First, the necessity defense is limited in time. As soon as the necessity passes, the action should stop. It will be very difficult, I think, to determine when the state of necessity stops for purposes of the pandemic. Another difficult issue will be, how do you determine whether the action went too far? Was it the only option that the government had? And of course, the fact that certain states have taken different approaches only lends to the difficulty in answering that question. And then, of course, there will be arguments about whether the state contributed to the state of necessity because of their differing approaches. And we know there are states that ignored or downplayed this problem at the beginning. Brazil comes to mind. And there's a question as to whether those states will have contributed to the crisis and therefore precluded from bringing necessity defense. So that's the fourth issue that I think will give rise to some controversy. So that's my summary of the four issues. I think the distinctions between cases, of course, will many times turn on the facts, as I've said, but I think much controversy probably awaits us, and perhaps inconsistency in decisions as well. Thank you.
Thank you very much, Jeff, and thank you to all of our panelists.